Hello everyone. In this video series, we are going to start the Hindu Marriage Act 1955. So let us start from understanding the term Hindu and who all comes under the definition of Hindu. So Section 2 of the Hindu Marriage Act 1955 defines and says that the act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashaiva, a Lingayat, or a follower of the Brahmo Prarthana or Arya Samaj. So, to all these persons, the Hindu Marriage Act 1955 is applied, and these persons are called as Hindus. And to any person who is a Buddhist, Jain, or Sikh. Though Buddhist, Jain, and Sikh comes under a different religion, but for the purpose of application of the law, they are considered as Hindus. And the next point states that to any other person domiciled in the territories to which this act extends, who is not a Muslim, Christian, Parsi, or Jew by religion. This clause states the non application of the act. So, this act does not apply to Muslims, Christians, Parsis, or Jews by religion. And unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein if this act had not been passed. So, the Hindu Marriage Act 1955 do not apply to these religions, and also if there is any community or tribe which states that the tribe or community was not governed by Hindu law or they do not follow any Hindu custom or usage and they prove the same, then to that tribe or community the Hindu Marriage Act does not apply. So this clause explains the non application of the act. And in cases of any child, a child who is either legitimate or illegitimate, both whose parents are Hindus, Buddhist, Jains, or Sikhs by religion, in that case, child will also be considered as an Hindu. So, those children whose parents are Hindus, Buddhists, or Jains, then the child will also become a Hindu. And any child, legitimate or illegitimate, one of whose parents is Hindu, Buddhist, Jain, or Sikh by religion, and who is brought up as a member of the tribe, community, group, or family to which such parent belongs or belonged. So, in cases where either of the parent is a Hindu, Buddhist, Sikh, or Jain, but the other parent, that is, for example, if one parent, that is the father, belongs to Hindu, but the mother belongs to Christianity. So the question is here the child born to them should be considered as either Hindu or Christian. Then, in that cases, so it is seen how the child is brought up. So, if the child is upbringed as an Hindu and according to Hindu religion and they have followed all Hindu customs and upbring the child as a Hindu, though the mother is Christian, then the child will be considered as Hindu only. Or if the child is upbringed as a Christian, then the child will be considered as Christian. So, according to the upbringing of the child by the parents, the child's religion is recognized. The next clause says that any person who is a convert or reconvert to a Hindu, Buddhist, Jain, or Sikh religion, those persons are also considered as Hindu. So, if a person who is a Christian has converted into Hindu, Buddhist, Jain, or Sikh religion, then that person is called as an Hindu. So, all these persons are considered as Hindu, and the Hindu Marriage Act 1955 shall apply to these persons. So now as we have understood who are called as Hindu, now let us understand the application of the act and the purpose for enacting the Hindu Marriage Act 1955. So the act extends to the whole of India, applies also to Hindus domiciled in the territories to which this act extends and who are outside the said territories. So the Hindu Marriage Act applies to the whole of India and also it applies to those Hindus who are outside the territory, that is India. So, for example, if A went to UK for higher studies and have got a job and settled in the United Kingdom, and B also a Hindu who is in United Kingdom, and now both A and B wants to get married. So they shall marry according to the Hindu Marriage Act 1955 only. So they shall follow all those conditions which the Hindu Marriage Act provides. So, though A and B are living outside the territory of India, the Hindu Marriage Act shall apply to both of them as they are Hindus. The Hindu Marriage Act is an act of the Parliament of India enacted in 1955. Three other important acts were also enacted as part of the Hindu Code Bills during this time. So, not only the Hindu Marriage Act 1955 was enacted during this time, but also three other acts were also enacted by the Parliament of India. That is the Hindu Succession Act 1956, Hindu Minority and Guardianship Act 1956, and Hindu Adoption and Maintenance Act 1956. So, all these acts, that is the Hindu Marriage Act and Succession, Minority and Guardianship Act, shall apply to all Hindus. So, now let us understand the purpose for enacting the Hindu Marriage Act 1955. So, the main purpose of the act was to amend and codify the law relating to marriage among Hindus and others. Besides amending the codifying Shastric law, it also included separation and divorce, which also exist in the Shastric law. So, this enactment brought uniformity in the law for all sections of Hindus. That is, the act deals with marriage, divorce, separation, maintenance. So, all these procedures came under one single law, that is the Hindu Marriage Act 1955. So, it brought uniformity of law for all sections of Hindus. So, this is the purpose for creating the Hindu Marriage Act 1955. So, this is an introductory class, and in the next video, we will understand some important definitions under the Hindu Marriage Act 1955. So, that's all in this video. I hope you all have understood it. Thank you.